My name is Jeff Morgan. I am from Dallas, Texas. In the Supreme Court of Texas, second emergency order regarding the COVID-19 state of disaster, it is ordered that number one, Governor Abbott has declared a state of disaster in all 254 counties in the state of Texas in response to the imminent threat of the COVID-19 pandemic. This order is issued pursuant to Section 22.0035B of the Texas Government Code. In the moment that I read this, I wanted to know what exactly does Section 22.0035 of the Texas Government Code say. So looking at the Texas Government Code, and this can easily be found online, Section 22.0035, modification or suspension of certain provisions relating to court proceedings. Court proceedings, nothing about court orders, but court proceedings affected by disaster. Now, A says in this section, a disaster has the meaning assigned to it by Section 418.004. B, notwithstanding any other statute, the Supreme Court may modify or suspend procedures for the conduct of any court proceeding affected by a disaster during the pendency of a disaster declared by the governor. An order under this section may not be extended for more than 90 days from the date the order was signed, unless renewed by the Chief Justice of the Supreme Court. Now, this is what the Government Code says. This is 22.0035B says that the Supreme Court may modify or suspend procedures for the conduct of any court proceeding affected by a disaster during the pendency of a disaster declared by the government. Nowhere in Section 22.0035 of the Texas Government Code does it say that the Texas Supreme Court has the right or ability or authority to change orders, to clarify orders. This is strictly regarding court proceedings. It has nothing to do with orders. And yet the Texas State Supreme Court appears to be a little bit activist in their interpretation. And this really concerns me because some of the people on the Texas State Supreme Court, actually I like a lot. I have been fans of theirs. I've followed some of their rulings, and I think that they're good. However, we must call a spade, and we must call an activist court an activist court. So they claim that this order is issued pursuant to Section 22.0035 of the Texas Government Code. I've just read 22.0035B of the Texas Government Code, and it talks only about court proceedings. So now that they've laid the groundwork on how they are issuing this order, here is what it says. Number two, this order applies to and clarifies possession schedules in suits affecting the parent-child relationship. Okay, wait a minute. I thought this was only supposed to deal with court proceedings, not in clarifying possession schedules in suits affecting the parent-child relationship. But they continue on further. They're trying to snowball you. This activist Texas Supreme Court is actually trying to snowball the public by citing their authority from the Texas Government Code 22.0035B, which has nothing to do with what they are doing right now. For purposes of determining a person's right to possession of and access to a child under a court-ordered possession schedule, the original published school schedule shall control in all instances. Now, how did they get the authority to actually supposedly clarify this issue? Number one, there has been no case heard. I know that the family court judges have been trying to issue their opinion, their belief, their stance. They have been predisposing themselves as to how they will rule. They are doing so in opposition to what they are allowed to do. They are depriving people who actually would have a legitimate case in front of this court of due process. They are actually stating that they are predisposing themselves to a judgment. And I think that it's important that we realize that, because according to the Texas Rules of Civil Procedure, a judge must recuse himself or herself under the following circumstances. So Rule 18B, the grounds for recusal and disqualification of judges. B says the grounds of recusal. A judge must recuse in any proceeding that, number one, the judge's impartiality might be reasonably questioned. The judge's impartiality might be reasonably questioned. Without having heard any legitimate case, real case in front of them, these judges have colluded together, it would appear, to opine, state their belief, state their new stance on a hypothetical case that has not yet appeared before them. Without any knowledge of the facts, they have already issued, in essence, a ruling. One might say, indeed, these judges' impartiality might be reasonably questioned. Yet nevertheless, now the Texas State Supreme Court is going to come in and maybe come to the rescue. Maybe the cavalry coming to the rescue for these activist family court judges that have actually played their hands out and really should be recused henceforth from any case pertaining to this issue, because they are predisposed to a certain judgment and they can be reasonably shown to be not objective, not unbiased. But the Texas State Supreme Court decides to up the ante. This activist court, and I'm sorry to say this because I know some of the people, and I like a lot of the people on the Texas State Supreme Court, but they have become activists in their interpretation. They have cited the Texas Government Code, section 22.0035, which actually talks about court procedures, and have now claimed a new type of authority. Again, I'm a person, I'm not an attorney, I'm not a lawyer, I don't understand all this constitutional law, but I can't read English. And the plain meaning of English is that this has nothing to do with orders, with clarifying orders, with clarifying possession orders. Now, according to these justices, perhaps legalese or judgeese or whatever we want to call it, has had a special insight to what was not written, but what should have been written. These activist Supreme Court justices are in the wrong. These activist Supreme Court justices should immediately declare that their order is completely invalid without an actual case, without hearing any actual case, without hearing any facts on the matter. They have already predisposed themselves as to how they would rule and what ruling they would uphold. So not only have the Texas Family Court judges predisposed themselves and are recused, now the whole state of Texas, the Texas Supreme Court, has sided with them. And they have predisposed themselves to an opinion or a belief or a stance of these Texas Family Court judges. They cannot even henceforth, in my opinion, even render judgment on this issue. Possession and access, according to these activist justices on the Texas Supreme Court, shall not be affected by the school's closure that arises from an epidemic or pandemic, including what is commonly referred to as the COVID-19 pandemic. And once again, I would like to ask the Texas Supreme Court justices, how exactly did you read Section 22.0035B of the Texas Government Code and come up with the ability and the authority to actually make this judgment? No case has come before you. No case has gone through a lower court. It's not been appealed to you, but somehow you are, in essence, the Texas State Supreme Court, making law, issuing an interpretation with no real facts before you. You are ruling on a hypothetical. You too, and I'm sorry to say this, are no longer able to judge this case objectively. If I go back to the Texas Family Code, by the way, and the Texas Family Code, as I've mentioned in the past, I'm not even a fan of. I believe that much of it is completely unconstitutional. I believe it's a mess of contradictions. But Section 153.312 of the Texas Family Code says this: the possessory conservator shall have possession in even-numbered years. 2020, for those who don't understand, a digit that ends with 0, 2, 4, 6, or 8 is considered an even-number year. The possessory conservative shall have the possession in even-numbered years. This is according to the Texas Family Code, beginning at 6 p.m. on the day the child is dismissed from school for the school's spring vacation and ending at 6 p.m. on the day before school resumes after that vacation. It does not say unless there is a pandemic or something like that. It says that they shall have possession ending at 6 p.m. on the day before school resumes. Now, these activist judges, whether they be family court activist judges or the Texas State Supreme Court activist justices, they cannot make law from where they are. They cannot clarify something that has not even been appealed to them. They are ruling on a hypothetical. Every single one of them. They are predisposing themselves. You cannot guess justice in these systems. My belief, my understanding of the law, and once again, I'm not an attorney, and I don't speak legalese, and I don't speak attorneyese, and I don't speak judgeese. I speak English. I understand and read plain English, not convoluted English. According to the plain English reading, it says this, that the possessory conservator shall have possession in even-numbered years, beginning at 6 p.m. on the day the child is dismissed from school for the school's spring vacation and ending at 6 p.m. on the day before school resumes after that vacation. School districts are extending that vacation. According to the Texas Family Code, the possessory conservator has every right to keep the child until the day before school resumes after that vacation. And the managing conservator shall have possession for the same period in odd number years. It is a shame that we have a Texas State Supreme Court that is supposedly a good court. And again, I know a lot of these people and I like them, but they have taken an activist position. They have done something that they are forbidden from doing, and these Texas State Supreme Court justices as well should not be eligible to hear any cases regarding this. They are predisposed in their decision, and a person cannot receive due process in front of them. And being as it's about ready to storm, I'm going to stop. Thank you.